of what you have as an answer. What's the issue? Where would you start? Okay.
Psychiatric harm.
Okay. Why do you see that as the issue? What in the facts led you to that?
Essentially just her breakdown after she realizes the truth about Charles. And essentially, they're kind of alluding to like it seems like they're starting off with a lawsuit with Mustafa to establish like duty care. And then based on the fact of saying how her family or friends recognize her behavioral changes, it's kind of going towards Sadati a bit.
Okay.
But then for myself personally, I'm really struggling with establishing duty care underneath Mustafa because
You're struggling with, sorry?
struggling with like establishing duty care underneath Mustafa.
Okay. Struggling how? Like struggling with this,
well,
or
essentially making a contention in her favor, because I think it's because I don't think a person with normal fortitude would have a psychiatric breakdown over just like because somebody just lied about who they are or didn't even mention about the other aspects of their life, and then kind of blaming a dating service for it, right?
Okay. So another way of addressing the exam questions is sort of you read it through and you come up with what Balkar has, like a summary of what you think generally the answer is or how you would go. And then what I suggest is you sort of break that down, because within what Balkar said is sort of the headline, but then we need to go through the more detailed analysis. So we have the 4 steps of a negligence claim: duty, breach, causation, remoteness. We've identified what type of harm or loss has been suffered, so we know that it's the duty of care for psychiatric damage. As Balkar said, the test is outlined in Mustafa, and Sadati sort of gives us a bit more on that. So, and he identified duty of care as an issue. Is that the only issue?
No, I think the breach is the issue for me.
Okay.
Even if I can say there is a duty of care, they have to match carefully the profiles.
Mm-hmm.
I mean, what is the breach? I mean, they should check every single profile if there is an investigation against these people, because he was a lawyer, he had an investment I mean, it looked like a perfect match, right? And
They
this
often
lady,
do, and then they let you down.
well, yeah, but then also the lady was dating for several months, so she had all the chances to check whatever
The
she
lying
wanted.
bastard.
Yes. So my problem is the breach.
Okay.
I can see the damage part. Okay, she has true damage. She changed personality. I see she was in hospital. She needs to take a break. Whatever. I see the damage part.
Mm-hmm.
I see there is no problem that there are no. There are only witnesses of family. That's fine, but
Right.
I don't see the breach.
Okay. Dayon.
Well, I was thinking about what Zita has said. I mean, I feel sorry about Charles in the first place. He got shafted here, but anyway, it's not about Charles. Unless they want to join to the kingdom. I mean, I'm thinking this like from an exam perspective. I would actually try to pierce everything all together. Duty of care, standard of care, causation, and remoteness. Like, duty of care, there are arguments that, may not exist for a number of reasons, but then you will just conclude if I was wrong,
Mm-hmm.
and there is a duty of care for a certain reason, then I would go down to
Yeah.
standard of care.
Yeah.
Make some analysis based on the assumption that there was duty of
Yeah.
care. Again, provide the answer, and again, if I was wrong.
Yeah, that's how. So, Dayon, in case it wasn't clear before, what Dayon is outlining is.
Well, you said that before.
Yeah.
You want the full analysis
Yeah.
instead of saying, "Bingo, I got you here. Go home and that's it."
Yeah, like I know it seems a bit pedantic, but I think getting into the habit of going through the full analysis is useful for a variety of reasons. So, as Dayon said, the way you sort of progress is if there was a duty of care, then breach. If there was a breach, I don't think there was, but if it was found that there was, then causation, and so on. So I think what Dayon is saying to him, there's an argument that against Diana at each stage of the 4 points of a negligence claim, in his estimation.
Yes, but there are also probably a couple of pro things, pro Diana case on certain levels, and maybe in terms of personality change, maybe, I don't know, I would have to go through my notes delicately, but there's certain parts where the causation and remoteness are involved, where we can bring in Sadati and insist on personality change as being a result, and then try to connect it.
Yeah.
But as you said, it's pretty much calling it the way how the story is unfolded in front of you. And you should tell Diana, well, look, this is what maybe you had, and this is what I think your good and weak points are, and try to take it from there to some sort of a conclusion, which would always be, if you give me a big fat retainer, I'll do whatever you want. Right?
Yeah. Yeah.
We'll sue the Supreme Court of Canada, no problem.
Yeah. So, and also just to flag the point, in case it was missed, at the end, I noted what duty of care to use, meaning established or novel. As I said before, I would tell you within the facts. Sometimes I'm able to integrate it within the facts, sometimes it's a bit more overt, like this time, but you will be told. And again, the reason for that is so that you don't have to worry about an extended period of time talking about, it may be an analogical duty of care, but if I'm wrong, here's my analysis of the novel duty of care. And I said generally in practice what you'd have to do is prepare both if it's on that borderline. But for exam purposes, I'm saying for the time constraints, I'll just tell you which one of those to do.
Question out of curiosity. You said, assume that this is not a novel duty of care.
Mm-hmm.
Is that for real? Is there a case about this?
About this?
Yeah.
No, I haven't found a case on this.
Okay.
I just made it up.
Okay.
And there was no personal experience. I didn't meet a guy named Charles. Actually, the inspiration for this was Diana and Charles, the royal family. But beyond that, there was nothing else that I drew from in terms of case law.
And Charles got shot at me. Everything was hunky-dory for him, and then...
I think he'd agree with you. Well, I don't think too much of a guy who just got married calling his mistress on his wedding night, which apparently is what happened with Charles. So I don't think that was ever destined to be a happy ending. So we've sort of talked a bit generally about this. Let's go into the details. Duty of care. What's the test for duty of care here? As modified by Mustafa. So you'd write down the stages. What's the first stage of the analysis? The first question.
Is there a duty of care?
Well, yeah, but within the ends, Kamloops.
Okay, so reasonable foreseeability and proximity, but we have to take into account that a person should be of a normal fortitude.
Right.
And
So
if
in
the
your
risk was reasonably foreseeable for a person of normal fortitude.
and in that elaboration, you note that you draw this from Kamloops and Mustafa, just outlining the authorities that you're drawing from for your analysis. So just if we stop there, reasonable foreseeability in a person of normal fortitude and proximity, what are the arguments there? I think, generally speaking, it seems as though people think Diana has a tough argument. So it seems like we have one side that'll maybe be a bit easier than the other side. So let's look at those competing arguments. For that first stage of the ends Kamloops as modified by Mustafa, what kinds of arguments do we have? And again, as on Monday, it's just more about orally going through what you'd mentally be thinking about in an exam. So how would you apply those criteria here? Sorry.
So an argument for Diana, I think an app which role is to match to people who do not know each other should foresee that when doing so, because the people who will meet each other, they want to find their soulmate, something like that. It's a serious task to undertake, and it has repercussions in their personal life. They try to find someone who will give meaning to them, to their life, and like, so it's not like they purchase a bag or something like that. So
They purchase what?
A bag.
Okay.
It's not like, it's more important.
I like the analogy that Charles is like a bag.
Yes, it's not just a bag, and they didn't check.
Some people might qualify the type of bag he was. Go ahead.
So if a person who is a known person for committing frauds, and you allow this person to enter the app, or yes, you match this person with another, you can foresee and that it will have it can cause psychiatric damage, because
Yeah. I think one thing I'd qualify though is he hasn't been convicted of fraud,
Yes.
right?
Yes.
No one knows
No.
that.
Nobody
He's
knows
being
that.
investigated.
Yes.
And the reason that I note that is
But
just
nobody knows.
don't be careful when you're using the facts.
Yeah, no, it's not obvious.
Not to misinterpret or something. This is something that I see often comes up. I'm not saying you were doing it, but it's more if you misinterpret or misread things, then sort of everything goes off.
Yeah,
So
that
here,
can-
I think the argument would be along the lines largely of what you said, that there's an obligation on for your soul to check these
I
people
think
to
especially
some
with
extent.
electronic transactions, and because we know like electronic crime is in the rise, and when you, I think electronic services, when they suspect that somebody commits fraud, even if it's only suspect, I think they should I don't know, have something like alert, not alert, but because people rely on these services, that the information is accurate. That's why they go there instead of searching like in the bar or something. They
Yeah.
want to find somebody with certain characteristics, and to
Yeah.
be sure from the beginning that, you know, so if this person was not a lawyer, so this is part of the, it's in the.
Well, you're buying a service, right?
No.
Like these aren't free.
No.
If
Yes,
they're
exactly.
free.
That's what what people are paying for, like to have some real life.
Yeah.
So basic search or something that. Yeah.
So I think what Constantine is talking about here is there's something there grounding an argument for Diana that when you sign up to something like this, like so personal, you would think that something more has to be done for the people. What that something more is can be debated, but it's when I wrote the question, it got me thinking about these kinds of dating applications and so on, and how much of a minefield it must be for legal issues, because you're purporting to set people up with their, like what I see on CNN, they used to advertise, this one old guy comes on and talks about, oh, I have the perfect algorithm and I'll match you with your soulmate. And it's like, buddy, you know,
And
what are
there
you
is-
talking about?
Well, don't they have exclusion
Yeah,
clauses?
they must
Yeah,
have an
sure.
exclusion
All around
clause
about
in the
everything.
contract.
Yeah, so I overheard you talking about that. Now, I will tell you this, and I'll give you a concrete example. The TTC, Toronto Transit Commission, they ran a Twitter account. And sort of the seedy underside of Toronto is there are some people who are homophobic, racist, and so on. And what happened was people would take photos of drivers or TTC personnel, link TTC, at TTC Helps was the handle, link it there and say this homophobic or this gay something, just throw all this stuff out there. The TTC had no policy whatsoever. No social media policy or anything for this. So what we consider what I might call no-brainers, sometimes there was no brain. You'd be surprised at how many people, universities, for example, many of them don't have a social media policy, which is kind of insane when you consider how many people tweet, for example, through things. So I agree with you, there should be, but it's not out of the realm of possibility that it wouldn't be there. The other thing is, I didn't put an exclusion clause here because then that would bring it into a contract matter, and I wanted to isolate it to the one area. Zita.
Yeah, I just want to, you said before that when we are applying the law, maybe we just have to ask questions first. So here, if we want to go to the direction helping Diana or
Mhm.
for Diana, then we have to ask questions. Like,
Yeah.
was there any check? Was there any? Did the site say anything which would assume that they were checking anything? You know,
Yeah.
or was there? Or this investigation was already in process? Who the website knew about it? Did Charles sign anything which says that there is no
Sure.
any, you know, I mean, there could be some questions which
Yeah.
would force to, I mean,
I guess I'd ask, would answers to those questions make a difference here? That's what I'm not sure about.
I'm just
Because,
saying
let's
that-
say they did vetting. Would anything have come up here? Would any flags have been raised about Charles? You know, and I don't know, even if they did do something, I'm thinking of, you know, the affirmative duties stuff in tort. We don't have that here, you know, because they've already said, come use our service, so there's already a positive action. But the question is sort of, how far do you have to go? You know, we made sure the guy's not Charles Manson. Box ticked.
So this is also about standard of care, the second. Does it also link how much?
Well, they kind of overlap a bit, but I think I took Zita's point to be, you know, was there any sort of, what went into the carrying out of the duty?
and also what was the duty which the website did not do or breach, which Diana could not do.
Yeah,
She had 3 months to check this fellow, right? So
At
even
least,
if
yeah.
the investigation maybe was not even in proceed when they made the match.
yeah.
But
Well,
if-
it seems as
but
though it
if
was a
but if
secret.
it was already, but still there was 3 months going on, and if Diana couldn't check it, you know,
Yeah,
then how the website 3 months before should have.
yeah, and that's why I asked the question, even with the questions you pose, I don't know if they would necessarily change anything
Yes.
here.
But-
That's, so when you ask, earlier I said, if you think that there are more facts to be found out, what I'm saying here is, ask yourself, would answers to those questions change anything here? Because maybe, well, we don't have every detail, we have enough to make an educated guess. Spartak, and then, because Spartak had his hand up.
Yeah, I wanted to build a little bit on this line, because if they did vet Charles, then it would be easier for them to kind of bring up the argument that we did our best. But with this case scenario, they didn't do anything, just took Charles and they said this is a perfect match. So it's kind of hard for them to bring up the argument later on that we did everything and for some reasons we were misled
Sure.
and it was.
What your argument, I think, kind of reminds me of is the Barnett and Chelsea Hospital case in causation. That even if we find there's a duty that was breached, did this cause anything? I think there would be a problem there with these facts.
Yeah.
Because even if they were lax and so on, nothing that they did actually caused this to transpire.
Right.
For your soul, I mean.
Yeah, my question is, I think for your soul or whatever your name is, they are liable in a way because I think they also have done proper due diligence because for a dating site, it should be, you know, a priority for them because matching people, just like you mentioned, Charles Manson or whatever, you know, the killer. Imagine, you know, matching somebody with a lady with somebody like Charles Manson.
Yeah.
What's, you know, fatal.
Or even,
results out
you've heard the case of Gian Gomeshi,
Yes.
the former CBC personality who engaged in what we might call rough sex, and there were charges laid against him. So you don't want that kind of person.
That kind of a person. Or assuming, you know, the other person, Charles or whatever his name is, happened to be somebody who is, you know, infected with some kind of, you know, terrible disease.
Yeah, although I guess
mean,
there I
sometimes
would.
you can say, okay, on the part of, what's her name? Diana, maybe there was contributory negligence.
Yeah.
Yeah, but then still, you know.
Well, yeah, and I think your point is valid in that we can look at, well, what was done, what sort of obligations does for an operation like 4 Years Soul sort of automatically assume by the business that they're engaged in when we speak of duty and the reasonable foreseeability and then proximity queries. That said, I think if we just sort of push on a bit more.
I have just one question, I apologize,
Yeah.
before you go. I mean, wasn't here anything about negligent misrepresentation in tort?
How?
Well, I'm looking at the, some sort of a special relationship and the agency is quoting itself as a matchmaker,
Mm-hmm.
in a sense.
Yeah.
Where you can draw at least some, or cut some slack for Diana, that based on that kind of special relationship,
Yeah.
there was a duty on the agency to ensure that there is some kind of correct match in between.
Yeah. So Dayon is noting the criteria that we saw with the landmark case from the UK, Headley Byrne.
Everybody,
The three-part
I disagree with
case, three-part criteria, which have been modified by Hercules Management. But if we just focus, sorry, I should say, Hercules Management will be the test, but just for our discussion purposes, if we take the Headley Byrne criteria, ostensibly they seem to apply. There's a special relationship, as he said. There was reliance by Diana on 4 Years Soul, and arguably it was reasonable. Let's give her the benefit of the doubt.
Oh, the name is tempting, like 4 Years Soul.
Yeah.
Almost like a guarantee that your soul will be
Taken
properly.
care of.
Yeah. So, but I think we also have to look at what do each of these torts, or if we're looking at contract, each of these contract tools do. What is their purview? And remember the definition of misrepresentation in tort, negligent misrepresentation. A false, unambiguous statement of fact that induces another party to enter into the contract. And I think we find a real problem with applying that definition here, because we don't have a false, unambiguous statement of fact. Even if we give Diana the benefit of the doubt and saying, well, she was clearly induced to sign up with this group as opposed to someone else. So it's a great question that affords me the opportunity to say, think about what each of these claims are about. What's the topic about? But I think Dayon brought up a very good point. It doesn't quite apply here, but I think I like that he brought it up, and I want to encourage that just because these are the things that you will think about on the exam. And what as long as my voice isn't in your head, if you think about, well, what is this claim about? Does the claim actually fit? I know the test is there, but this is about X. And it doesn't quite fit that definition. So I keep that in mind. But it's good to look through things.
So basically the rule is don't even try to stretch it out. I mean, the institutes are meant to be institutes. You cannot draw some inference from potentially forming some negligent misrepresentation than to say, well, now there is a duty of care on the side of it. It's a too of a stretch.
I think it's a harder one, especially if we originally started with Balcar, looking at the duty of care with psychiatric damage. I think if we compare those two claims, the more favorable one for Diana would be psychiatric damage. Because, again, what was lost in terms of negligent misrepresentation? We could say, well, she lost some of her business. Maybe, the facts don't get us as far as psychiatric damage. So, as a secondary argument, you can say, well, maybe there are further facts that would help this. Here are the points that I see as problematic for negligent misrepresentation. Here are some of the pros for Diana. But as it stands now,
yeah, realistically speaking, like it's like obviously a big stretch to try to push this.
yeah, yeah, the facts aren't necessarily there. So I think as I said, what can be said is this is a secondary argument that's contingent upon further favorable facts.
Thank you.
So what I was going to say was, if we apply, we'll finish with the duty and then we'll take the break. Reasonable foreseeability in a person of normal fortitude. This is where Balcar, I think, started us. The idea that, well, is Diana a person of normal fortitude given what has transpired? I think the insinuation you hadn't gone further, the insinuation being, this isn't what the average person would have done. This is closer to a Mustafa than a Sadati, if we want to look at the spectrum in terms of psychiatric damage. So there's a hurdle for her. Is she a person of reasonable foreseeability? Is her harm reasonably foreseeable in a person of normal fortitude? Proximity, I think we do have here, because she engaged in the services of a 4-year soul. So there is a proximate relationship, a contractual relationship, if you will. And in tort, in these kinds of cases, that's okay. Arguably in negligent misrepresentation, these are contractual relationships that create the proximity. It doesn't necessarily mean that we have a contract claim, but it does satisfy that proximity aspect in the tort claim. So it's sort of a mixed bag at that prima facie level. Then we go to the policy considerations. And I think we've talked about this a few times. Sometimes the policy arguments can be hard. But I would go back to Constantina's elaboration where she talked about, let's think about what For Your Soul is offering. There are certainly policy arguments that would underpin establishing a duty of care here, or finding a duty of care between the parties. The difficulty again is she more a Mustafa than a Sadati? Is this, I'm trying to remember what Chief Justice McLaughlin wrote. I think it was paragraph 9 in Mustafa. Somebody of, we're not around to deal with hurt feelings and anxiety and unhappiness or despair. This is about something sustained, something substantive. It seems like, while unfortunate, Diana reacted in a way that was beyond what the average person would have engaged in. And so I'm putting the 2 points out there for you as an example of what would feed into a policy argument. We certainly see why there'd be a policy to find a duty of care here, but keep in mind what will be the repercussion if you did. There's another public policy argument that are you kind of stretching things too far so that you're going against what the Supreme Court in Mustafa explicitly said shouldn't be done, and that is, depression, despair, depression in the non-clinical sense. The problematic, sorry, go ahead.
I was going to say, and just to add to that contention, you can also argue that given that it is like an online application, then are users as well. So you can raise the floodgates argument, like similar to like they did in Aug28, to a certain degree, not
to
exactly.
It's not like Imperial Tobacco with indeterminacy, because it would be a closed off, arguably, I think. But what I was going to add is just, what sort of unsettles things, just like I talked about on Monday with contract and consideration, Williams and Rafi. Here, Sadati kind of opens up the spectrum of what constitutes harm in psychiatric damage cases. If you recall, I contrasted that with the elaboration, the history of the duty of care analysis, where we had courts in England and Canada being concerned about duty of care expanding too far and creating too wide a capture area. And that psychiatric damage seems to be this outlier within that trend, that arguably with Sadati, the court expanded what could be harm and what was the reasoning behind it. They were saying, well, we don't want somebody, this is me sort of putting in lay language what they're saying, we don't want somebody who's suffering from a mental health issue to be barred from bringing a claim just because they don't fall under the DSM or something recognized by a medical professional. We're going to allow for people to put forward evidence that if they can't provide psychiatric diagnoses, that they can put forward what we call testimonial evidence, that there was, in Sadati's case, a change of personality, and here are her friends and family testifying to that point. So as I said, we'll take a break there. Just a bit of a shorter break. I have about 1:45, so say 8 o'clock, just so that we can wrap up the tort, and then we'll go on to the final question, and a bit of time, hopefully, for any final questions.